Invention and inspiration. So this morning we'll start up with a panel discussion of the wireless industry and of mobile tech. And so I'll hand it over to Devlin Hartline, who is one of our newest CPIP staff members and our assistant director in charge of our publications. So Devlin, thank you for moderating, and take it away.
All right, thank you, Mark. Good morning, everybody, and welcome to day 2 of our conference. My name is Devlin Hartline, and I'm the assistant director here at CPIP. And I have the pleasure of moderating today's panel, which is on mobile technology. We have 4 excellent panelists. To my right is Kristen Osenga. She's a professor at University of Richmond. Keith Mallinson is the founder of Wise Harbor. Lenny Kravitz is a patent counsel at InterDigital Solutions, and Morgan Reed is executive director of ACT, the App Association. And without further ado, Kristen Osenga.
Any slides? Okay, good. Thank you. Got it, thanks. Okay, great. As they mentioned, I'm Kristen Osenga, a professor at University of Richmond School of Law. I'm also thankful to CPIP to be one of their senior scholars. So they support some of my research, which is fantastic. As you know, the theme of the conference is supporting supporting innovation and invention and inspiration, the IP platform. My talk today is going to tee up some of the issues that will probably be covered better by some of my fellow panelists. But the gist of what I'm going to talk about is how IP should or doesn't, maybe should and does and shouldn't, support collaboration and innovation in the interconnected world, mobile technology. So, I'm a professor, I have to do slides, sorry. So the first thing I'm going to do is talk a little bit about collaborative innovation, which is very important in the interconnected world, so I'm going to talk about that. I'm going to talk about how collaboration occurs across the innovation cycle, and then I'm going to talk about how IP presents some challenges to collaborative innovation and maybe tee up some ideas of things we might be able to fix. So what is collaborative innovation? Collaborative innovation is, what I want to talk about with respect to collaborative innovation is private-private collaboration. Oftentimes when we think about collaboration, we think about government-supported research and how the money comes from the government, private industries or universities use it, but there's a lot of collaborative innovation going on between private firms, and that's something that isn't often looked at, even though it happens an awful lot. In fact, we heard yesterday, even from Hannah from Steelcase, that it goes on not just in the interconnected mobile technology world, but even as far as office furniture. So I want to talk about that. People are interacting at all sorts of levels of development of new products, new networks, new infrastructure, as well as collaboration that goes along with developing complementary products. And that happens an awful lot too. So it's important for lots of reasons. Obviously, collaboration is important because of the sum is greater than the whole of the parts. There's also a benefit to sharing costs. There's a benefit to sharing risks. And so that is good. It allows faster development if you have lots of parties working together. And also, especially today, we have a lot of firms with specialized knowledge. You're very good at chips. You're very good at cases, you're very good at whatever. So because we have firms that have specialized knowledge and specialized personnel, it helps to have all of these groups working together in order to create a product, given how complicated and complex some of our stuff is. So not only is it important for all those reasons, but in the internet and technology space, communication technology space, since this is the mobile tech panel, It's important because of the network effects. It's impossible to create interconnectivity and interoperability without collaboration. And the way that mobile technology works is that we need the networks, we need the network effects, we need multiple adopters to create those network effects, and so we need manufacturers working together, creating products that all work together so that we get the network effects that we want in the mobile technology space. So that's why it's so important. Now, last annual meeting, yes, last fall, we had Professor Richard Epstein do a fantastic keynote address at this very same meeting. He didn't actually talk about this, but he talked about a lot of other great stuff. But he says that in the innovation cycle, there's 4 stages. You have your initial startup, then you get some money infused in, then you commercialize your patented product, and the 4th stage, he says, is protecting the underlying rights, and that kind of holds the other 3 stages together. I want to take that idea and give you 3 different stages to think about when we're talking about mobile technology. And those stages are pre-standardization, standardization, and post-standardization, which fall kind of in line with Epstein's stages, but more specialized for ICT and mobile technology, which is what I want to talk about. So pre-standardization, what's going on there, the collaboration, is there's a couple of ways it happens. So we have consortia. We have research consortia get together to develop technology outside of standardization. Okay? They do that for a number of different reasons. One is just simply to take advantage of the benefits of collaboration, sharing costs. Some of it is the research consortia in the ICT world is useful to bring a stronger product into the standardization process. And sometimes they do it hand in hand with standardization. Sometimes they do it before standardization. But that's one of we'll just call it pre-standardization. Then we get to standardization, standard setting organizations, okay? The idea there is all collaborative. That's exactly what standard setting organizations are. It's a group of people coming together to pick an optimal technology solution to a problem. And so there's give and take, there's people working together to share risks and benefits, and so standardization is the model of collaboration in my mind. Then finally, we have post-standardization collaboration. And what that looks like is patent pools, firms getting together to get their patents all together to license them out. It looks like people sharing knowledge and information to develop complementary products in the ICT world. And so those are the 3 categories I want you to think about as we move into how does IP help or hinder, those 3 places. So how does IP fit in? Does it help, hinder, or hijack? If you know me at all, you know I love IP, and I think it's fantastic. So I think IP should help the standardization, or should help collaborative innovation. I don't think that IP hinders collaborative innovation, except that there's some tweaks that we might need to make to the system. So let me talk now about how IP fits into those 3 areas of collaboration that I just laid out for you. So pre-standardization issues. Okay. This is firms getting together to develop products and technology outside of standardization. The problem there for IP is in general, inventorship, who owns stuff. The patent system isn't super friendly to collaborative inventors. It's very difficult to determine inventors. Obviously, a lot of this stuff is done under contract. Contract fixes all sorts of sin, but that's okay. But just looking only at the patent system, joint inventors, there's some concerns there, and inventorship. And so one of the things that probably would improve collaborative innovation at the pre-standardization time would be something along the lines of more clear information about inventorship, more clear rules for collaborative. The AIA has added some stuff to, obviousness when you have joint inventors and et cetera, et cetera. So those are some things that are problematic, that they understand that there's more and more collaborative research going on, but and Congress is trying to fix some of the collaborative issues, but it's not quite fixed yet. Then we have standardization. Standardization. Standards are great. Standards are very helpful for interconnection and interoperability. The problem with standardization is that a lot of judges, a lot of legislators, a lot of commentators don't understand standard setting. They don't understand how it works. And so a lot of the decisions that come out of the courts with respect to patents that are involved in standards are very harmful. And so it's very difficult to encourage standard setting if the patents that are involved in standards are going to be problematic. So some of the things I'm talking about here is FRAND. We have FRAND, the Fair and Reasonable Non-Discriminatory Licensing. Courts are taking that and creating very unfriendly rates. We'll call it unfriendly rates. So there's very unfriendly rates that are being set by courts because they don't understand the collaboration and effort that goes into standard setting. They think that it's just people sitting in a room swapping patents, which is not at all what happens in standard setting. And so one of the things that needs to happen is some education of judges and legislators and proposals, people who create proposals. There's a proposal out there currently. Does anybody know how baseball arbitration works? Like, you submit it, he submits it. Yeah, there's a professor out there who said that what we should do when there's a FRAND negotiation breakdown is baseball arbitration. Oh, that's spooky for anybody out there that's participating in SSOs. So, and part of it is, again, because I would like to say, I don't think this person understands how SSOs really work. He is confused. So that's one of the things that's wrong with it. Another thing is that a number now of standard setting organizations, because of some of these FRAND problems, are saying you don't get to have injunctions. Well, that's a concern too if you're a patent holder. And so people who have patents will be less likely to participate in standard setting organizations if they're going to get lousy FRAND rates and or not be able to enforce their patents through injunctions. And what does that do? It removes collaboration. The less people who want to participate means less collaboration. Less collaboration means less of the benefits that I talked about with respect to collaboration, and that's a real problem. So those are some things that have to do with standardization. Then finally, we have post-standardization issues. So some of the things with post-standardization issues are things like patent pools, which also are kind of getting dinged in the same way that standard essential patents are in standardization. Patent pools are also viewed very poorly. They have antitrust problems, which is something altogether different. In general, the patent pools have been deemed okay as far as antitrust goes, but a lot of it depends on the scope of the patent. Well, all of y'all know that determining a scope of any patent is a mystery. And so the idea that at some point some of these patent pools could be viewed as antitrust issues simply because the scope of the patent is determined to be something different than what we all thought it was could be a real big problem. So those are the kind of main issues that I wanted to tee up with respect to collaboration and standardization. Can any of them be fixed? I think so, but I think a lot of it comes from education. And I think that what we have to do, all of us, is educate. What we have to do is educate the people, the judges, the judges, the legislators, and the proposal people, people coming up with stupid proposals to fix these problems. So education is key. And I'll turn it over.
All right. Thank you, Kristen. Next up, we have Keith Mallinson.
How do I do this? Thanks, Kristen. My name is Keith Mallinson. I am not a lawyer. I'm an industry analyst. So I've worked in the telecoms industry for decades, with a particular focus on the mobile markets, the cellular technology markets and associated products. And what I'm going to talk about here today is really the success of the smartphone market. I was asked in preparation for this panel whether I was going to talk about FRAND, and so that's an interesting question. I wasn't, and I'm not intending to talk about FRAND very specifically in my talk. I'm happy in questions and answers afterwards to drill into some of the FRAND issues that Kristen has already raised. What I'm going to do here is, as a backdrop to that, to show what has occurred in the mobile phone or the smartphone market, to show that these products, which are subject to literally tens of thousands of patents, subject to a lot of other intellectual property, have been the basis of a very, very successful market. And it's been on the basis of FRAND licensing, fair, reasonable, non-discriminatory licensing for the standards essential patents, and subject to other intellectual property. We've seen a very, very successful market. So it begs the question, where there are those around that are suggesting that there are some market failures, when we look at the actual acid test of a market, probably the most intellectual property intensive market going in terms of certainly patented intellectual property, we see something very successful. So just a little bit of backdrop of a recent product, the new Apple iPhone 6S. The manufacturing cost is about $225. So there are companies that can actually pull these phones apart and see what they cost to construct. The unsubsidized price of that handset is about $625. So we've got $400 of additional cost there, or a margin, if you like, for Apple. Now, Apple clearly has a lot of value in its brand, in its copyrighted software, but a very important element in that product, of course, is also the standards essential technologies that include the cellular capabilities, also some Wi-Fi and video codecs and such like. So this is the only time I use the term FRAND is on this slide. You're probably aware of the criticisms of the FRAND system and the possibilities that you can get with these thousands of technologies reading on the capabilities in a mobile phone, that you've got the possibility of hold-up and royalty stacking that predict, and these theories predict all sorts of harms in the marketplace. So you would expect stifling of innovation, you would expect slowing down of R&D investment and such like. But actually, what we see is the market is actually proceeding extremely well. You know, it's passing all the market tests with flying colors. So we have consumer adoption and consumption is increasing. It's a very, very innovative marketplace, and by all accounts, everything's accelerating. We find with new standards that the products are actually, and the new technologies are actually coming to market more and more quickly with each successive generation of technology. We find, whereas initially the marketplace was very much vertically integrated players, we find that there's a collapse in that, and that the original technology developers have gotten out of the handset market, and we've had floods of new market entrants, and market concentration is reducing. Prices are falling, and actually the royalties, when you actually look at what the royalties really are, if you look at the facts of the matter, you find that it's actually, the payments are actually a relatively small proportion of the total cost of the device. So some of the kind of scaremongering theories that the royalty stack on a smartphone could be hundreds of dollars, are absolutely incorrect. There is no evidence for that. In fact, there's plenty of evidence to show that quite the reverse is the case. So here we are. Here's just some stats, and I'm going to run through the rest of my slides pretty rapidly, because they're very data intensive, and I just want to make a few headline points. So 7 billion subscribers worldwide for mobile phones. That's the fastest diffusion of probably any product ever. And we've got a very large market of $400 billion in handsets and $1.2 trillion in service revenues. And bear in mind, these technologies, these standard essential technologies in cellular, are implemented in the networks as well as in the handsets. And so everything is benefiting from this. So we've got hundreds of companies, hundreds of thousands of patents, and you've got the standard setting organizations are moving very swiftly with lots of participants. The performance of the networks are increasing. I mean, literally, on a smartphone today, you've got the maximum data speed is about 1,000 times what it was a decade, 15 years ago. Many devices available and such like. And here's just showing the migration to smartphones. And really the modern smartphone came around about the time that the iPhone came into the market in 2007. And they were, we had BlackBerrys before that. Maybe that was a smartphone, a type of smartphone. But there was a transition, definitely 2007. Now, most people in certainly the developed world for several years, and increasingly even in the developing countries, are all taking smartphones. And so the sales are 500 million units per quarter. The network and the usage has transformed enormously as well. Whereas we used to do voice and text a decade ago, now the predominant use and most of the traffic, most of the usage of the network is in the data services. And until maybe 2008, 2009, the traffic on the network, the bits, if you like, traveling over the network were equal between voice and data. Now you can see from this chart that data outstrips voice massively. And this has been possible because of the massive innovation in technology and such like. And it's a function of and what has been made possible by the R&D investment in the sector. Here, what I did is I just looked at companies that were predominantly in the mobile technology business. So there are 12 companies there. Some of these companies clearly do other things. So Samsung's in there. They clearly develop TVs. But all these businesses, they make most of their business out of cellular technologies. There are other companies that do cellular, but maybe they're predominantly something else. So this is just a benchmark. I think it's a reasonable kind of feel for the R&D intensity in the marketplace. And $50 billion a year in R&D is quite substantial. And this 3GPP is the standard setting organization that does most of the stuff in cellular nowadays. And they have a major standards release every year or two, and every new release has literally hundreds of enhancements and features that are being put into the standards. And interestingly, in terms of participation, a study showed a few years ago that for LTE, which is the fourth generation technology, for all the contributions that go into the standard, only about 1 in 6 actually gets adopted. So there's quite a lot of attrition, a lot of ideas going in this collaborative process, a lot of R&D beforehand, but it's a selective process, very collaborative, but it's also competitive. And it's a system that seems to be working extremely well. And with the new technologies, we're finding actually the adoption, the time to market, if you like, from standard setting to launching on the market is increasing. Again, another signal, another indication of a very healthy market, not one that, not a phenomenon you would expect in a hold-up kind of market where you expect, if you like, bad stuff or negative things and slowing down and stifling to occur. This is very noisy, this chart, so I'm not going to get into the detail other than just to say that this, on the left-hand side, we've got what was the leading kind of smartphone in 2006. It was a Nokia device. The features and functionality there were massively improved on by 2013. The smartphone on the right there, the Samsung device. So massive increase in performance, so in economic terms, big increase in quality, but meanwhile, the price for the device has dropped substantially. 24% cheaper after inflation. And similarly, we can do a comparison between that Samsung device and a 2014 device and find that we're getting yet more performance and yet lower prices. And here is using some Bureau of Labor Statistics data where I'm trying to do the quality-adjusted price comparison and for different types of devices. And see the CPI at the top is going up, but everything to do with communications equipment, wireless technologies and such like is going down. And remember, on a weighted average basis, the mobile technology marketplace is predominating now. So in these indices, we're seeing that it's very much an increase in performance that you're getting for a lower price. So again, another positive signal of the system that's in play. And the systems in play, certainly with regards to patents and standard essential patents, is this FRAND-based licensing. Vertical integration and new competition, very noisy chart again, but the simple thing is here is most of the old players have collapsed. And it's the newcomers that have been on the rise. So we have Apple coming in from 2007. Samsung had actually been around quite a while, but only really started in smartphones around about 2008. Prior to that, it was producing feature phones. And then the red line there is the others. So there's a whole swathe of new market entrants. Again, another very healthy sign of the market competition. I'm just showing the companies that were once handset names have all exited the market. Some of those names actually still hang around. You can still get an Alcatel branded phone, but it's not from the original parent. Motorola brand still exists, but there have been a couple of ownership changes. So the original technology developers have actually exited. And this is significant because many of those original technology developers are still developing the technology, and they are looking for a financial return on their previous investment and for their current and future investments. And that's why the licensing system is an important issue here. And here is just a blaze of different names, new market entrants, and how they have grown. And most of these are Chinese, but not all of them. And for those of you who are familiar with antitrust, this is just a more quantitative way of looking at how the market supply for handsets has changed in terms of the number of competitors. It's a measurement of market concentration. So using this index called the Hirschman index, the HHI index, you look at market shares, you square them, and it gives you an index of how concentrated the market is. And it's amazing that in the last few years, the market has become less and less and less concentrated. Again, a very, very positive sign of a healthy market. And I'm going to go a little bit more rapidly here, just showing Apple and Samsung are the ones that are making most of the profit. All the other players are in there fighting, hoping. They're kind of wannabes, if you like. They want to get big and successful. But overall, there's quite a lot of profit in the marketplace, but it's very polarized between certain strong players. And I have some data about Apple in there. Is this presentation going to be made available for? Okay, so I'll leave some of the material there as a takeaway. But this final analysis here I'd like to just show is these companies here, 1, 2, 3, 4, 5 of them. These are 5 companies that were very significant in developing the cellular technologies originally. They are continuing to do so. And but most of these used to be in the downstream business for devices, and that's handsets, and that's where most of the revenues are generated, and actually overall where most of the profits are. And yet, because they're out of that downstream business, they have the capabilities to continue to invest in R&D and want to do that. They are very dependent on the licensing fees that they can generate. And here I'm just showing how much they've generated in royalties in 2013, 2014. And so it adds up to about $10 billion, which looks like a big number. But actually, bear in mind, the handset business is over $400 billion. So as a percentage, these guys only account for a few percent. So the notion that there's this massive royalty stack that could be accounting for 20, 30% of the cost of a handset, as has been, if you like, say, speculated. There was a paper by Intel where they were suggesting it could be at those kinds of levels. There is these guys are clearly not collecting it. And I have written a paper on a blog I've written for IP Finance recently, where I went beyond this and looked at all the other players, the patent pools, some of the awards in litigation and such like. And it shows that this total accumulation of royalties is actually no more than about 5% for standards essential patents, and probably not a lot more even when you add in the non-standards essentials. The interesting thing, instead of the royalties stacking, you tend to get a lot of offsets, for example, cross-licensing. You get a lot of discounting going on. And even when you add non-essentials to essentials, sometimes instead of the royalty stack, as you might call it, going up, it actually goes down. Look at the litigation between Apple and Samsung, for example. Samsung, relatively strong, maybe on standards essentials. Apple has no real history in standards essential patents, but it claims that it has a lot of other intellectual property, and it sued Samsung for it. You can just see, in terms of, there's a headline award there of $1 billion, but not yet been paid, and the interplay of the standards essential and non-standards essential intellectual property shows that the likely outcome through settlement or other means is actually to reduce the overall payment, the net payment between the players. So there's a lot of payment in kind, if you like, but that's really an offset for the R&D that everyone's doing. The actual payments, the money exchange, is actually nothing like as much as led to believe. And I think there's a lot of deception in the industry. I mean, there's a standards group, there's an industry association called Next Generation Mobile Network Alliance, where I was at an event recently, and they're a group that like the idea of cramming down intellectual property costs. One of the speakers there was saying there is the perception that intellectual property costs are too high. And I asked the question, well, tell us what the figure is. And they weren't really willing to do it. They'd rather have the world feel that there's overcharging going on here and that the prices are high, because they like the idea of reducing the charges. But in actual fact, all evidence is that the charges are actually relatively modest in comparison to the enormous amount of value, as I've shown in my presentation. Thank you very much.
All right, thank you, Keith. Next up, we have Lenny Kravitz.
So I have the, excuse me, unenviable task of following Keith. So hopefully I'll add something new to what you just presented, but I'll give it a shot. So I was asked to talk about how the intellectual property system works for InterDigital. Usually when I say I work at InterDigital, the first question I get is, what's InterDigital? So I think Keith did a great job. For those paying attention to his slide, we were one of the 5 companies as sort of being there for being major contributors to the development of cellular standards previously, and as you said, still are. So we are a public company. We have a $2 billion market cap. We have R&D offices all over the world: Korea, London, US, Canada. And basically, we work in cellular. So we contribute to the development of wireless technologies traditionally, and today we're working on some of the technologies sort of enabled by the work that has previously been done in cellular. So we're working on what 5G is going to look like, which I'll get to, and the Internet of Things, which is all about connectivity of all kinds of devices. So that's sort of where we are today. So to really understand InterDigital, I think you really need to understand sort of how we got to where we are, where everyone has a smartphone, and that smartphone is probably the most powerful computer on the market, basically. So hopefully everyone can see this, but this is a very high-level view of what basically how we got to where we are. So the first cell phone call was placed by a Motorola engineer on a street corner in Manhattan, 1973. InterDigital's predecessor company, it was a different name, but same company, it's actually founded in 1972, so we've been there basically through all of this. And the idea here is basically, at a very high level, each one of these technologies gets commercialized, and that's what we know. That's what, that's why we have these great data rates, that's why we have all these things. But for the 10 years leading up to commercialization, there are these very significant, intensive R&D efforts that are organized through these standard activities. And as we talked about, the intensive collaboration, or collaborative innovation that Kristen talked about, that process is, it's super interesting just to see what happens in a company like InterDigital, because what I really like is going to talk to some of our engineers and find out basically the stuff they're working on today is what we can expect to see 5, 10 years down the line. So as you look at this, I mean, 1G, that was the very beginning, right? And so we had, basically that was the introduction of cellular voice. As 1G was commercialized, the work on 2G started, and 2G was basically the real beginning of cell phones as a popular tool. So 2G gave us sort of those, well, I guess the star tax for those that remember them, the basic cell phone. Towards the end of 2G, as we transitioned into 3G, we had feature phones, right? So in the early 2000s, we had Nokia and companies like that gave us the phone with some additional data features. So either you had a camera or maybe a browser and you had some internet access or other features like that. And then with the introduction of the iPhone and really the transition into 4G, we got into the smartphones that we know today. And so if you overlay that with what basically that looks like from a handset perspective, you see that there's companies, basically with each transition, you get a particular set of companies that really takes over. So in 1G, Motorola, they kind of led that. As we transitioned into feature phones, we had Nokia, we had Sony Ericsson, et cetera. 3G, with the introduction of the iPhone especially, we had Apple and Samsung. And what we're seeing today with 4G is the rise of some of these, as Keith talked about, some of these companies that probably didn't exist even 5 years ago, like Xiaomi. We have Micromax in India, Huawei, and companies like that really are able to exist because there's been a ton of work done through the standards bodies in getting us to the point where today, if you want to start a handset company, you only need a couple of things, right? You need you can go to Microtech and get your wireless chip. You can go to Google and get your Android operating system. And then you go to Taiwan and you can get a manufacturer like Foxconn to basically build your device. So as you can see, basically, each one of these companies, they've all been involved in various levels in these standards activities, but basically the level changes. And so what we have, or where we play in this, is we kind of view ourselves as a long-term shepherd, or a long-term, taking a long-term perspective on the wireless space. So whereas the handset guys, they have, you saw the various smartphones and how quickly those develop. So a lot of that has to do with the fact that, if you need to release a new phone every year, you're really focused on what those features are going to look like. What's the feature that's going to sell your phone? Not, the fact that you have data, or the fact that your data speed is increasing, that's, basically everyone gets that. That's not a differentiating feature, really. And so companies like InterDigital and Qualcomm and Ericsson and Alcatel-Lucent, all the companies, again, on Keith's slide, are the companies that can take a sort of a longer-term view of what this should look like. And that's exactly what we do. So how do we do that? Well, again, I'm not going to talk too much about this because I think we've kind of covered it, but basically all these companies participate in standard setting organizations, IEEE, 3GPP, ETSI, et cetera. What's interesting is that the standard setting participation is actually way up. So companies like Huawei are realizing the value of standards, and they're increasing their R&D investment and really participating. And InterDigital is no different. So we have we've made hundreds of contributions to 3G mobile spec. We're doing the same in LTE and LTE Advanced, and now we're doing that in 5G. So getting to the original question, how does IP work for InterDigital? Well, I think the first point that I think is important is the fact that InterDigital, in the mobile space, InterDigital is really no different from any other company. We're all basically trying to make a return on our investment, and we do that through research and development. Now, our research and development is sort of long-term. It's focused on, improving the cellular technologies that a lot of this is based on. So, again, how do you get better battery life from the network connectivity piece? How do you ensure better data rates and so on? And long-term innovation and a view of the long term it's incredibly important, right? Because just as it's really important to have these great new features in your next handset, we want in 5 years we want billions of devices connected to our networks and communicating with one another in the Internet of Things. So we take a view of that, and the only way you can really make a long-term investment in R&D, especially given those 10-year cycles, is with the possibility of an ROI being there at the end of that cycle once commercialization begins. Now, I think it should go without say that when you're better at doing something, you should be rewarded for doing that. And so we view ourselves as being very good at innovation. And so generally, if you're very good at innovation, you should be rewarded with a higher ROI. So that's kind of our take on this. Standard setting organizations play a significant and important role in all this for us. And so what we do is, obviously, we go out and we do standards-based IPR licensing. So we have a portfolio of, I believe, 20,000 patents last time I looked, worldwide, which is pretty significant. And that all comes from the investments we make in R&D. So I believe in 2014, we had our R&D investment was $75 million. And so we would probably see a return on that money probably around the time that 5G gets commercialized, which is probably going to be around 2020 or even further out. So we really have to be confident that to make those kinds of investments that we'll be able to basically make a return on that. And that's why everything we just discussed in terms of FRAND rates and so on is very important. The final point I'll make is that just as we talked about with specialization in the supply chain, so the fact that you can basically go out and get your microphone chip from one place, you can get your wireless chip from another place, and so on and so forth to build your device. So the fact that a lot of the actual design process has been outsourced from the vertically integrated players that we saw in 1G and 2G, the Nokias and Motorola's of the world. The same thing can be said of innovation. So the fact that a company is very good at innovating in a particular space, I think is actually should be and is a important competitive advantage in this space. So that's something that I think we're very proud of. So having said all that, how do we do all this? We have a couple of different avenues, right? So through our technical expertise, we participate in standards organizations. We have engineers who are leaders in those organizations. We do a lot of work in a lot of different areas. Going forward, we're looking at, again, obviously wireless technology is probably the most important, is the core, but also Internet of Things platforms, security, analytics. All these things are kind of creeping their way into the mobile space, into 5G. And so we take a long-term view on that. We also partner with other companies. So actually, for those that pay attention to this, yesterday we had a press release announcing an expansion of our relationship with Sony through the Convita joint venture. So that was focused on Internet of Things. Now we're partnering with them to work on Internet of Things and also 5G research. And finally, we take our sort of our long-term R&D, and when we have something interesting, we'll develop commercial solutions. So we have various solutions that we partner with in terms of improving network management. We have sort of spin-out companies that do these types of things. One is XLAir. So all three of these avenues are sort of enabled by the fact that we can be confident in making investments in R&D. So just as a teaser, I think this is kind of our view of where this is going next. So connectivity is obviously always going to be the core, and it's very important. But then we're also increasingly looking at Internet of Things, which is probably most companies are looking at that. But we take the view of looking at it from the standpoint of how do you enable all of these, like, I think Cisco predicted 50 billion devices in the next 5 to 10 years, I believe by 2020. How are all those devices actually going to talk to each other? So we have a 1M2M, which is another standard-based platform. Again, I talked about XLAir briefly, managing basically small cell networks. And then we do work in analytics, again, around the concept of improving sort of the data that comes, or using the data that comes out of these activities. And with that, thank you.
All right, thank you, Lenny. Next up, we have Morgan Reed.
Guess I probably have to be over here. So I'm going to try to take a slightly different approach. I'm going to tell you all the things that they missed and talk to you a little bit about the realities of small businesses in this space, and then finally take a slightly different perspective on some of the standards essential patents view. But first, a little show of hands, because I saw some sleepy eyes in there. How many of you have a smartphone? Show of hands. All right, thank you. Next question, how many of you have ever started a small business, or have you ever started a small business? Much lower number of hands. How many of you are practitioners in the IP space? Oh, okay, so we got some double hands going off in there, which is good to see. How many of you have ever used an app on your smartphone? Good, so here's the part that I thought was really interesting about our first three panelists. And I don't know any way to say it, nobody cares. Without the apps that run on the smartphone, there is no $400 billion handset market. Bottom line. So the question is, with all of this wonderful charts and graphs about how much money we're making, because I'll tell you, do you know what a smartphone is that doesn't have apps on it? It's a phone. And we know exactly what the shape and scope of the phone market is. So the driving force that we all see in this environment is the applications that run on top of it. Now, of course, in reality, we absolutely need the platforms that these folks are all talking about and where they're coming from the perspective of. Without that platform, we don't have it. But never take your eye off the prize, because I thought Lenny said something that actually scares me about this market. He said, you know what, it's not hard to make a smartphone. You get your operating system here, you go to Taiwan and go to Foxconn, you get your chip from this company, and you know what I call that? I call that a commodity. And I hate commodities, because we all know the pricing of commodity is really simple. We go there, it's pork bellies, it's Trading Places, it's Eddie Murphy. I don't like that. I like intellectual property and the ability that intellectual property gives you to make something not a commodity. So what I heard today were two things. One, we've got an exploding platform for other people's IP to be valued. And if we're not careful, from Lenny's point, the people who are in the business of making handsets, with the absence of Apple, won't have much going on because they're in a commodity market that generally drives prices down and forces you to compete for features for less money. So I thought it was interesting that Keith's slide talked about how, guess what, these things are worth less. Well, if you're doing a small business, if you're doing a business, that sucks. I made 24% less money after inflation? Yikes. So I think what's really important for us to take a step back from, since most of you are practitioners in this space, you're going to want your clients to be in a position where they can make more money, not lose 24% of their potential revenue after inflation. And so I want to talk all of you through what it's like a little bit to be a small business that's entering either as an application or as an IP rights holder in something where you're beginning. I saw a few hands go up on folks who've started a small business. First thing that happens when you start a small business is you're running scared and you're broke. So your first engagement with intellectual property that almost always happens is the trademark. How many of you watched a show called Silicon Valley? Excellent. Do you remember that weird episode where he had to rename his company because there was a sprinkler company that had the same name? That's not a joke. That show is practically a documentary on Silicon Valley. I've actually gone through it. I've started a couple of companies. I've been through the naming process. It's amazing who comes out of the woodwork claiming they have your name. People you thought were taken care of come out and boom. So the first step that your new client is going to have, his first introduction into the IP system, is going to be the trademark space. Protecting it, surrounding it, making sure that you have it covered. And your failure to do so as a practitioner in this space is probably the thing that will submarine his business first. One business that I was involved in lost a year, while everyone internally basically navel-gazed and tried to come up with a new name, when everybody involved was terrible at naming. I mean, some of the names were just atrocious. And yet, that was what took cycles away from developers, from production, from reaching out to new clients, from making sales. So trademark, first place you enter into this environment is the trademark. And remember, your client is broke and running scared. The next place that often happens in this space, in this application economy that we live in, the ones that run on the platforms that these guys are making, is you almost always try to make a little extra dough by doing services and support, which means white boxing. Everybody know what I mean when I say white boxing? Okay, no, good, excellent. So, most of the applications you are currently using on your device are not written by the company whose name is on the app. They are written by a bunch of my members. My members, over 5,000 companies around the world, make mobile applications. But they don't just make the ones for themselves. They make the Bank of America app. They make the app for Condé Nast. They make all of those applications. And so this gets into a very interesting sticky wicket for your potential client, which is, I need to make some extra scratch. I'm going to make a mobile app for Condé Nast. Condé Nast comes to me with a contract. We're in a copyright space here, folks. What IP rights am I giving up at that moment where I am engaging with Condé Nast? Remember, I'm broke and running scared, and Condé Nast comes to me with a contract, and maybe that contract includes a clause that says, we own all intellectual property rights from the production of this product. Oh, crap. Now that one product you started the company to build that's in your dream, that keeps you up at night, that you're sure will be the next Angry Birds, you now think if that module that helped you build that application underneath, did you just give that right away to Condé Nast when you built that white boxed app for them? That's the second question that you need to start when your client or your company that you're part of is asking. How have you protected your copyright in this environment when you're probably doing work for hire? The third category that happens all the time is you hire a couple of good engineers. And one of the things that happens in this mobile, enabled by all the devices we heard from today environment, is you work from home, and you work in the shower, and you work when you aren't thinking about it, when you're at lunch, at that coffee shop that's actually your office because you're too cheap to buy office space. And so now the question is, when you hire 3 engineers and they're working at all these places, how do you know when they're on the clock? How do you know when that idea that engineer had is owned by the company he's working for and not himself? Anybody here familiar with Slack? It's a hot unicorn right now. I see 2 hands. Slack is the hottest collaboration software out there. Slack, the company itself, did not form from a company to build collaboration software. The owner, the founder of the company, wanted to make a game. He spent millions of dollars building a game that sucked. However, the product he built to help his engineers collaborate so they could build this not-so-great game was a product that was amazing. And everyone who uses it is like, this is amazing. I'm able to share documents, I'm able to have stream, I'm able to have history. There's an entire universe of information that he has. That's Slack. Now here's the question for your client. If the engineer who comes up with the idea that's the next Slack while you're making that product that isn't any good, did it on his own time, what are the IP rights? So as you approach a client in this, remember, running scared, he's broke. One of the things to make sure of is, what do his employment agreements look like? One of the things that we always run into is, if you walk into a small business and say, who manages, well, I'll ask you, I'll flip it around for a second. In your office, do you know who's in charge of birthdays? The person who makes sure that there's a birthday card or a cake. Most of you are, if you're in any kind of office, there's somebody who's the birthday person. The number of small businesses that I walk into that can tell me instantly who the birthday person is 90%. You know the number of small businesses I walk into say, who's the IP person? Tiny. Your IP should be at least as important as your birthday person. And so when you're dealing with your clients who are small businesses running scared and are broke, remind them that as they build their IP portfolio, as they're thinking about their trademark, their copyright, their work for hire, how they're managing their employment agreement, that it should be in a binder at least as important as the birthday person. Which brings us to the next major transaction that happens for an IP-based company, and that is venture capital. Now, you're always told to get the venture capital to sign an NDA. Most of them won't. Fight them on it if you've got good IP. If you can't get them to sign it, figure out how you're going to manage that. How do you handle it? Because I'll tell you, VCs gossip like crazy. I go to the Valley and I do speeches and talks with big developer conferences and with venture capital. I hear so many things that I really shouldn't hear in the backstage, in the green room, talking, getting a cup of coffee. So figure out how you lock that stuff down. Because even the act of fighting it tells the venture capitalist that you care about your intellectual property. You're probably going to lose, because remember, your client's broke. They're going to lose, but at least you've sent the message, IP matters. And so that brings you to the next stage. So you've got your venture capital, and you're moving forward, and you're trying to figure out how to get your product to market. And you know what? You've realized I'm going to have to partner. I can't make my sales, or even better, I can't make my sales overseas. Well, same thing goes. What are your partnership arrangements? What is a partnership agreement? What is the IP term in your partnership contract? For your client who's broke and running scared, make sure you've got that nailed down. And then we get to that idea. Remember the one the engineer had because you locked it up, so even though he had it in the shower, you own it? It's patentable. Excellent. Now remember, when that idea happens, 9 times out of 10, the guy who owns that company is going to say, wait a minute, you want me to spend $30,000 to $50,000 just to start a patent proceeding? $50,000 is half an FTE for a developer. Average salary for a developer in America is about $92,000. If you go to the Valley, it's $250,000. But at $92,000, if you come in as a practitioner and say, to file this patent is 50 grand, you have taken half of an engineering talent away from that company. So it's really got to be worth it. And you heard earlier that somebody was saying, well, you know, claims construction and scope is so hard to tell. Well, that's actually part of the reason why the industry, my people, I have to fight them to tell them that patents are not a bad thing. Those developers who make the apps that actually drive all of your devices that you actually care about, huge chunk of them hate patents. And they hate it because of the uncertainty it provides. Because they're broke, because they're running scared, they don't know who's going to copy them. And they see IP from the framework of fear. And so patents represent that. So as a practitioner, part of your job is to explain to your client, look, I understand you're scared, I understand you're broke, but this is the thing that will give you the leg up. And so when you think about that, the best thing you can do when a client walks in the door and makes the call and says, I want to start a small business, or you've got a friend who's talking about it, is to say, look, start putting together a binder. Start thinking about your intellectual property at the beginning. Don't try to make the hard sell on why they have to get a patent. Tell them about the 1-year rule. Tell them about the other things, but understand the process they're going through. First trademark, then copyright, and then hopefully patents. Now some of them might come from a big company where they understand the value of patents. And then they're going to walk in and they're going to be your perfect client. They're going to want a patent on day one. That is not the reality for most of what you see in the mobile sector that's on top of the platform that these folks all talked about. And so since this audience is majority practitioners, I would say take that as your place. Make your order, have your steps, and know how you're going to approach it. And I would close, actually, though, with a little bit of pushback on some of what we heard about how wonderful everything is for standard settings and how royalty stacking isn't a thing. Because I thought what was really interesting about that was something that you said and something that Keith said. In juxtaposition, you started out by saying it's, judges are driving to prevent injunction, and there's all of this push for bad rates on FRAND, and it's really a bad thing. And yet Keith came in and said it's not a problem, the numbers look good. Well, wait a minute. If you're right, and in fact rates are too low, and there's not enough injunction, but Keith is right and things are going up, then that actually suggests that pressure on FRAND and pressure on injunction is actually in part responsible for the $400 billion that Keith pointed out. And so I would say from the perspective of the small businesses who are on these platforms, we don't mind intellectual property. Many of my people love IP and they believe in patents, but I think the perspective that they take is very simple. They don't have the money to be part of SCPs. They don't have the money to be engaged in this activity. Very few of them have patents that are taken up by standards. What they want is certainty. And I'm old enough to remember the good old or bad old days before we really had standards. When IBM was actually, most of you probably don't know this because you're not network nerds, which is probably healthy for you. Before we had TCP/IP, which is the protocol that runs the internet, IBM had a competing protocol that existed that they wanted to sell that was not a standard. And there was actually, if you go back far enough, we had Novell and they had their own. Packet switch networking, there were multiple different standards. Part of what allowed this environment to live and grow was that TCP/IP became an accepted platform on which to build. So my concern is if we end up with too much heavy pricing on royalty stacking, or an SEP, an environment of standards that is fearful, remember my folks are fearful, they will gravitate to the largest company they think that will protect them. In the 1970s, it was IBM. And I think that if standards start to be seen as something where injunction is possible, the handset might disappear, or we're not really sure if this network stack will survive, my folks won't raise up arms and, yes, sure, the free software foundation guys might, but my folks don't care. Remember, they're trying to build a business. They're trying to make that next amazing app. What they'll do is gravitate to a non-standard, large company protected space that they know they can build on top of. Because all of that stuff, it's just a platform. And our people are looking for the safest, most economically likely to survive platform to build on top of. So while I agree with what a lot of you guys said about standards and collaboration, I want them to survive. And my concern is that if we get it becomes too uncertain or too expensive, and the lack of ability to control that environment grows, my folks won't cause you problems in litigation. They'll just jump ship and go to the biggest safe harbor they can find. So in that regard, I think maybe a little of the pressure you don't like is a good thing. So I'll turn it over from there. Thank you, Devin.
All right, thank you, Morgan. Before I open it up to the floor for Q&A, I want to just jump on what Morgan just said, and I think it's really interesting because the consensus seems to be that FRAND is working. Kristen talked about collaborative innovation, sharing cost and risks. Keith talked about the successful market because of FRAND. Sales are up, speeds are up, R&D is up. Lenny talked about increased SSO participation. But I think it's a legitimate question that Morgan brought up, because how do we know that part of this success isn't the unfriendly rates that courts set? Maybe that's preventing royalty stacking. Maybe knowing that you can't get an injunction is stopping patent holdup. Maybe antitrust oversight is actually stopping anti-competitive behavior. And I know that Keith would like to respond to this.
Yes, I mean, as you've summarized, I think there's lots of evidence to show that the FRAND system is working, and yet there's a lot of pressure out there to modify it, to clarify, and to do things that will change the way the marketplace works. And so, for example, the antitrust authorities around the world actually are seeking to rein in or modify what's done under FRAND-based licensing, including in the United States. And some of the SSOs, standard-setting organizations, are responding. So, for example, the IEEE, which is responsible for Wi-Fi and many other standards, has changed its IP policy, and that new policy is changing, for example, the basis upon which the royalty rates can be levied or charged, the royalty base. In terms of injunctions, it's extremely difficult to get an injunction for a standard essential patent anywhere around the world, and very, very few examples of where it occurs. But to actually remove the possibility of getting an injunction, that does tilt the scale enormously, and effects are being noticed in the market. So the companies that historically were able to sign up licensing agreements for their portfolios of standards essential patents are now finding it very difficult to get the infringers to actually sign those agreements. They can't get meetings with them. When they go to the meetings, the people don't show up, or the people there can't make decisions. They're being strung out, and on the basis that will sue me. They're playing the game, and so it is changing the dynamics in the industry. So why is it necessary to do that when, for example, with smartphones, it's been enormously successful so far? In the absence of having evidence of actual harm, and my presentation showed that all the market tests are being passed with flying colors. Why is there need to change this just under the sort of self-interest of a certain part of the marketplace that has a certain business model that just likes the idea of not paying so much for intellectual property? So I think there's great danger in changing things, because it will discourage the investment, as Lenny has said. You need to be able to see a return. The other effect is the R&D may occur, but I think it's certainly possible that companies, the technology developers, will run shy of standardization and will tend to go back to the old days where things used to be done in a more proprietary way. So one has to be very mindful of the consequences, the unintended consequences of these kinds of changes.
Devlin, I guess the problem is that you've done the same equation, and that's the part. And in general, by the way, I generally agree with the value. You just said that you're concerned that people run away from standards if things get less expensive and more certain on standards. I guess the question that I have for the way that you're presenting it is, if things are good now, and as Kristen pointed out, there's pressure. I think that the idea that somehow releasing that pressure would end up being a good thing, or that we shouldn't do it, it just doesn't. We get circuitous logic. If we're liking where things are going, and there is incredible pressure, and as you just said, you actually just said there's market impact from this pressure, but your slide suggests the market impact is actually good for the sales of handsets. And self-interestedly, it's good for the mobile developers who build on those products, because we're looking at a marketplace of, say, China with 800 million subscribers to one telco. Those are 800 million potential clients. So I guess the problem is that I don't want to see us run from standards essential patents and the patents in the standard space. I agree with you completely, but I'm not sure that we want to make that bridge higher. I don't think we want to make it harder or more uncertain. I don't want to see more injunctions. I don't want to see higher FRAND rates. I don't want to see more royalty stacking situations, because right now we're trying to ride a rail, and that may be that may be something that we see use in. So I guess that's the problem. You're two sides of the same coin, and maybe we're just doing a game of edges defining the middle. I guess that would be a question.
I'll just say there's one thing. There's no evidence that the aggregate rates are increasing.
Right, so we have downward pressure
So I mean,
on rates.
there's pressure in both directions, and as I said, it's always been nigh impossible to get an injunction for standards essential patents anyway. So there is no need to change the rules to make it even more difficult, because that, I think, is an unhealthy effect of, as I say, tipping the scale.
But there is some benefit to right now the downward pressure on FRAND rates then.
You know,
That
it's a
exists in the
market.
current right.
It's a
So
market,
current
and I
market
think the
rates.
market
Okay.
functions well. It has functioned well on the basis that has existed, which has been FRAND-based licensing for standard essential patents in portfolios. And we can get into all sorts of other issues as to how the courts work, which tends not to be about portfolio of patents. It tends to be selecting individual patents, and there's a lot of complexities. So to apply things that go on in the courts, I think is yet another kind of intervention that could also create some other healthy, unexpected effects.
Do you have anything to add, Kristen or Lenny?
I think Keith summed up everything I would have said.
All right, we're going to open it up to the floor for Q&A. If you could ask a short and clear question. We have somebody right here.
So this is a fascinating discussion about SEPs and royalty stacking. And if you actually do the math in the royalty stacking literature, what you should see, because every SEP holder does not know what other SEP holders are charging as a royalty, and so the stack should get immense. And so what you should observe is innovations not taking place if royalty stacking is an endemic problem rather than something that's rare. Could somebody, I'm an outsider to this literature, so could somebody tell us about a technology or a product that didn't come into existence, did not get commercialized because there was a royalty stack?
It's not a technology that didn't come into existence. Remember, we're talking about standards essential patents, and the reality of the standard situation, we all know Wi-Fi is one of the most famous ones that everyone here has dealt with, and I helped work on some of the protocols of it. It's one of those bizarre things where you certainly had a battle of ideas within the standard space. Early on, two companies basically wanted to become the standard for what became Wi-Fi, two chip manufacturers. So what tends to happen in this environment is not a technology dies on the vine. What happens is that a different standard wins out. A different portion of the protocol, a different stack made up of a different group of patents. If someone's rate is too high, what happens is that the ants move to a more fruitful colony, and you end up seeing this was Lucent, this was the whole chipset. That ultimately is what happens. Everybody says, okay, who has another patent that can work around that technology? We're going to move around, and that's going to be the patent that's part of this standard. So, good question. I think the way SEPs work and the collaboration that happens drives people around obstacles rather than killing it entirely.
If that's the case, then royalty stacking is a non-issue. If it's as you described it, you just work around the stack. If it's as you described it, and you can find another route around the stack, then there isn't any patent holdup, and there isn't a royalty stack that public policy makers need to worry about.
I'll do the finish up on that. The problem isn't at the beginning when we're having that first battle of ideas. It's later into the process when the standard has been widely adopted and accepted. That's the moment where it happens. Rambus is a very famous situation that we all had, where all of a sudden, out of nowhere, somebody came. They're the worst. The one that we always use that one because it's the worst behavior. It's the worst example of bad behavior that exists. We all agree that shame on them. But what often happens, what concerns companies in this space is that everyone sits around the table, as Keith and Kristen mentioned, in a collaborative way. Everyone comes to terms. Company X, InterDigital, says we're providing our patent portfolio. The standard is widely adopted and deployed in devices. And then they say, oh, but by the way, in that portfolio, actually I shouldn't pick on you, some other company, not InterDigital, says, oh, well, we've got these 6 patents and we want to go and individually rate you for each one. So it's not the entire portfolio that you're going to pay for. We're going to say, well, this is an essential patent, you have to pay X. This one, we're going to negotiate. This one, we're going to negotiate. That's when the problem happens. Not at the birth of the standard, but once the standard has seen some success. And that's why, let's use Rambus, not InterDigital, since I'm sitting next to him.
Yeah, I think no one really, when there's an embryonic technology, people don't think too much about the IP costs. They concern themselves more with actually the technology getting going and implement it, and then, I mean, this is probably bad practice, but then they worry about the IP cost issues later. And actually, Wi-Fi is an interesting one because, I mean, if you did a poll of, you know, the general population and Wi-Fi, you know, what words would you associate with Wi-Fi? The one that probably would come top of the pile, I've never actually done this, but I would suspect the word free would probably be there. People regard Wi-Fi as being like air. You know, it's free in all kinds of ways. And WiMAX was the sort of wide area equivalent, you know, the sort of IEEE standard wide area kind of competitor, if you like, to the cellular standards. And one of the propositions when WiMAX was being promoted a decade ago was that it was going to be much cheaper from an intellectual property point of view. I think that's completely specious. But that was the kind of notion. You know, so that's the way things get going. And then once the market's moving, then people start to worry about IP charges, and that those are the paying them like to promote the notion that it's too costly and the price should be down. But I agree with you, Stephen. I mean, you know, there is the evidence for the stacking effects is non-existent.
So just to step back for a second, I mean, I think we're all talking about encouraging innovation. And as much as Morgan, I agree with you, I love app developers. I think they're, you know, most of my close friends are app developers or, you know, startup CEOs. I love them. Loved working with them when I was at a law firm. But by the same token, I mean, without the proliferation of really high-speed mobile data, we had desktop PCs, 1995, and basically unless you were Microsoft as an app developer, which one are you going to pick, right? I mean,
Microsoft or Microsoft? Yeah.
So I mean, while I agree with you, I mean, I think that the app economy in the smartphone world is incredibly critical. I think it's, you know, there's really a lot of value that goes into the fact that we have these, you know, incredibly interoperative and worldwide, basically standards. I mean, you know, you go to any country in the world with your smartphone, it's going to work, and that, I don't know, as long as you put in a SIM card, right? But so that in itself, I think, is a huge win for standards, and really should be encouraged.
Yeah, I think all of us are pro-standards.
Yeah.
I think the reality is I know what the world looks like in a pre-standard world from a technology perspective, and it's far slower, and you get less creativity. I think the question is, in a selfish sense, my members want to make sure that standards essential patents are as cheap as possible, and you want to make them as profitable as possible because you have shareholders to benefit. So I think our disagreement is as honest as it ever is in a marketplace. And so I think the real question that we're all going to see on this is that where do we all conclude, and where do we find a fine price? And so I enjoy that tension. I think it's healthy.
All right. Is there any more questions? We have about 10 minutes left. Can we get a microphone?
Hello. So I actually have been in the mobile field back from the early 2000, right? For a major mobile device company. And I query whether FRAND really works, right? Because back in the day, so I started, say, in actually 2001. And I don't currently work for the company anyway. But no one knew what FRAND was, right? I worked for a major mobile European company. No one knew what FRAND was. Everybody, you know, it depended on how many patents you had out there, and it was just a negotiation process. But at that time, right, all the big players were arguing at, you know, early 2000, oh, you know, it's got to be all this money because we've won all this money. Now come to the situation where, say, big mobile company sells off their mobile handset business, then, you know, when they had it, it's like, oh no, we shouldn't pay so much money because look at all these patents we have, but no one knew what it was, and this is how you kind of keep the smaller players out because you can, you know, they can't pay what big mobile company wants FRAND to be. So, you know, but then of course the times change when if you don't have the mobile device handset anymore, now you don't have much exposure, so you know, you need FRAND to be big again. So it's kind of ebbs and flows what people thought FRAND was, frankly. There has to be some value in getting stability on what it is, right? And I think that's what people want. You know, different people want different things depending on what their stake is in the game, so to speak. But I don't think it's a negative thing to ask for stability and a clear outline on what FRAND is going to be, because I think then there could be more players in the game, there's more success in this. So just from coming from over 15 years of looking at this, I definitely think that there wasn't stability in FRAND. Is there stability now? Has FRAND worked? I'm not so sure FRAND has worked, right? I think people want FRAND to work, and that's what the people are trying to do. That's just my looking at it from a licensing. I was in patent litigation and patent licensing on FRAND for many, many years now. That just seems how it's kind of worked out to play currently, you know, depending on whatever everyone's stake is in the game. So that's just my little kind of look at that. I see that.
All right, thank you. Keith?
Okay, yeah, I have a response to that. And if you turn the clock back a little further than 2000, in the 90s, there was a lot of criticism that IP costs were high for GSM, for example. So when GSM started in the 90s, so it was starting out, it was a European-centric technology. It became the global success, but there were some estimates that the IP charges could be tens of %. And that was really for outsiders who weren't contributing. So there was arguably a bit of a kind of Fortress Europe going on. There were a clutch, an oligopoly, if you like, of technology developers that cross-licensed among themselves, you know, the Ericssons and the Nokias and Siemens and such like. And that enabled them to be very successful and exclude others. I think there might be something in that. And, you know, that was the rise. You know, Nokia established a 40% market share, for example. But look what's happened now. You've got very low barriers to entry. All those major vertically integrated players have exited the market. None of them are in handsets anymore. Now, Morgan was saying, you know, it's, well, Lenny was explaining that the barriers to entry are very low. Anybody can sell a handset now. Anyone can get into that market. You know, that's a very healthy competitive situation. Now, it may make it very difficult to make profit for a lot of those marginal players, but it's definitely a very dynamic and competitive marketplace that has facilitated that. And so you've got standard inputs. You know, you can buy your chip from MediaTek, and you can get access to all these standard essential technologies and for a modest license fee. That is showing, I think, that the market has progressed in an extremely positive kind of way that has allowed that kind of market entry and competition. And the fact that it's driving everyone down to marginal cost is, well, you know, that's just too bad. That's just the way economics works. But it's a healthier situation than perhaps that early stage of GSM where there was much more of an oligopoly of, you know, a closed shop almost that was initially, at any rate, made it difficult for market entrants, new market entrants, to come in and compete with those guys.
But I think maybe part of that is because people are wanting security and to know what is FRAND. I mean, that's kind of what helps the market, right?
Yeah, actually, I think you raise a really good point, and I think it's a great question. And thank you for articulating what I was trying to say. Obviously, you did it better than I did. I think the certainty for the small businesses is exactly what they're looking for. I think the concern and why I've been pushing back a little bit on my fellow panelists, even though we're all supporters of intellectual property, is my concern is that there is a notice of what we all said, which is that these standards are becoming more popular and populous. And we also are noticing that we're commoditizing the handsets. So what I think you're seeing is people saying, where can profit-taking take place? And if the profit-taking can now take place in the FRAND environment, well, that's where people are going to do it. Because as you just said, it's easy to enter a market, they're practically a commodity, and FRAND is the lingua franca of the industry. Well, if I'm a business, then I'm looking for double-digit growth. And so if part of that double-digit growth can come from raising prices and royalty stacking in a way that allows me to charge for each element of my patent portfolio, from a business perspective, I'd be an idiot not to. And so to your point, there probably is some benefit to making sure we push back, well, at least some benefit for trying to keep clarity around FRAND, because from a business perspective, if I were, say, a hedge fund manager, I'd be looking at picking somebody up who's got that and figuring out how to extract maximum value from every single standard that my patent is part of. And that'll mean royalty stacking in individual rates. So I think you raise a really healthy point about certainty and where there's a tendency for markets to go.
All right, we have time for one more quick question. Right here, this gentleman.
Professor Osenga, I'm just curious to what extent you think the invisible hand of the Antitrust Division prompted the anti-injunction provision in the IEEE activity.
Wow. I don't know much. As you mentioned, it's an invisible hand. Yeah, no, I know. I don't know that the pressure came as much from the Antitrust Division as it came from some players out in the field. It really is something that a number of companies also are in support of for whatever reason. And so I don't know that we can blame the Antitrust Division for all of it.
I don't know whether I agree. I mean, on the record, Renata Hesse from 2012, her after lunch or before lunch speech or whatever it was, she's on the record of encouraging standard-setting organizations to change things. And I think that what happened in the IEEE is a clear example of that pressure, that sort of lightning rod. And the sad fact is that it's not just in the United States. There's a kind of ripple effect all around the world in multiple jurisdictions. I don't think it's healthy.
All right, well, I want to thank all of the panelists for coming out here this morning, and it was a very interesting talk. We're going to take a 15-minute break, and we will begin again at 10:15 promptly. Thank you.
Great job, and thank you for serving as my foils.
Thank you very much.